The storm just hit. Ivanka's case isn't just heating up, it's detonating from the inside. And the reason every lawyer in that camp is on full alert right now, the timeline's crumbling. When courts catch wind that your dates don't line up, it's not a minor hiccup, it's a 5-alarm fire. Because inconsistent timelines whisper one terrifying truth. Either you're twisting the facts or you're burying something that ties it all together. Right now, on this Tuesday morning, February 10th, 2026, that buried connection is being dragged into the light, whether Trump's team likes it or not. Let me walk you through what's actually unfolding here piece by piece. The narrative flooding your social feeds, polished, emotional, simple. But the court record, that's where reality gets ugly and complicated. And when ugly meets complicated in a federal filing, that's where the real chaos begins. 7 minutes past 7 this morning, Eastern Time, a bombshell lands on the docket of a fictional federal court in Manhattan's Eastern District. It's labeled as a notice, something about supplemental materials and a revised timeline. Translation, someone just walked up to the judge and said, "Your Honor, the version of events you've been hearing, it's not what actually happened." When that accusation surfaces in black and white, defense attorneys don't waste time drafting press releases. They're burning up phone lines in a panic because your timeline is everything in litigation. If that foundation cracks, your entire case shatters. 8 minutes later, 7:14 a.m., another filing drops. This one's a formal motion demanding clarity on what was preserved, what was claimed, and asking the judge to personally inspect a handful of sensitive items behind closed doors. Here's what that really means. Judge, we think they fed you a story about what they saved, what they protected, and who had access. We need you to look at the actual evidence yourself to see if their version holds water. Anyone who's tracked high-stakes litigation knows what happens the instant preservation and clarification appear in the same sentence. The entire atmosphere shifts. Courts lose their patience fast when preservation gets questioned. Then, at 7:22 in the morning, the third document hits the system. The exhibit list? It's not slim. It's not a single smoking gun. It's a bundle, a thick one. And bundles don't get filed over petty disagreements. Bundles get filed when someone's building a case that there's a pattern, a deliberate trail of behavior that can't be explained away as coincidence. Before we dive deeper, let's establish the framework here so everyone's on the same page. In this imagined scenario, Ivanka Trump stands accused in a blockbuster legal battle, one that weaves together business dealings, regulatory requirements, and allegedly false statements, creating two radically different stories. Trump's political machine, his public relations army, is working overtime to paint this as a witch hunt, a vendetta against a loyal family. Meanwhile, the legal defense is desperately trying to keep everything narrow, technical, and boring in court filings, because the narrower and more procedural this stays, the less likely a judge starts imposing emergency restrictions and tightening the screws. But today's the day everything goes sideways. Because this new filing claims the defense's own version of when things happened contradicts hard evidence from outside sources. If that's accurate, it's not just embarrassing. It activates every judge's instinct to question whether anything this team says can be trusted. And here's the part that makes this narrative framework so explosive. The meltdown isn't coming from external attacks. It's self-inflicted. The chaos stems from mismatched timelines, conflicting public statements, private messages that don't align, and procedural claims to the court that can't all be true simultaneously. The story being sold to the public in this fictional universe is clean and straightforward. There was a routine regulatory inquiry. The defense responded appropriately. Then things escalated purely because of politics, and now the family's being persecuted. But the story this new filing claims to reveal, that's where it gets dark. It alleges there was a window, a short window measured in days, not months, where internal decisions were made to reroute communications, relabel certain documents, and stall disclosures in ways that only make sense if someone knew scrutiny was coming. That's why the timeline's falling apart. Because if you swear you found out about a problem on Monday, but flight records, calendar entries, and vendor notifications show activity the previous Wednesday, the court doesn't need elaborate theories. It just needs you to explain yourself. That brings us to the 72-hour pressure cooker sequence, the kind competitor channels use to hook viewers and keep them coming back. Saturday, February 7th, A sealed notice from the court clerk appears, hinting that additional timeline materials are coming. Sunday, February 8th, a brief letter gets filed asking for an urgent meeting with the judge no later than Tuesday. Monday, February 9th, late into the night, a joint stipulation surfaces showing both sides talked but couldn't agree on anything. Tuesday morning, February 10th, the judge greenlights an emergency status hearing scheduled for 2:45 that same afternoon. 4 moves, 3 days, 1 outcome. The judge is now personally steering this case. And once a judge takes the wheel, public relations stops calling the shots. What makes this case detonate in storytelling terms is that this new evidence packet allegedly exposes a contradiction so severe it rips the family's strategy clean in half. The political side is screaming for aggression, come out swinging, attack the system, blame corruption, rally the base. But the legal side is begging for precision and silence until they can make sense of the conflicting records. Because if this filing's right and the dates don't match, the absolute worst move is to go on camera making bold, confident claims that later collide with sworn testimony. You can actually see that internal war playing out in how the fictional responses evolve. An initial draft statement declares, "We have always been fully compliant and will continue to be." Then it softens to, "We take our compliance obligations seriously." Then it gets delayed. Finally, it morphs into something vague like, "We will address these matters in court," which is the universal white flag signaling the lawyers won the internal battle. Now let's dissect this evidence packet using the competitor documentary breakdown method. Even though we're not citing actual pages here, the structure itself is the lesson. This is format training in action. Document 1 in this fictional packet is a supplemental chronology chart. It organizes events into 3 stark columns: what the defense claimed, what third-party records show, and where they diverge. The genius of this approach from a narrative perspective: a chart accuses without emotion. The filing doesn't have to scream, "They lied." It just has to display dates that don't align, and the judge's brain does the rest. In this imagined chart, the mismatches fall into 4 damning categories: shifts in how people communicated, who had custody of devices, the order of key meetings, and travel whereabouts. Communication shifts mean messages allegedly jumped from official corporate email to encrypted apps or informal channels right around the time compliance warnings arrived. Device custody means a phone or laptop supposedly locked in secure storage shows up in a third-party access log as active during that exact time frame. Meeting sequence means a gathering described as happening after the fact actually occurred before it, which matters enormously because before implies planning and intent. Travel timing means someone was physically present in a location they swore they weren't near at the critical moment, transforming a potential misunderstanding into a credibility crisis. Document 2 is a sworn declaration from a records custodian, someone who can tell the judge, "I pulled these logs directly from the service provider in a forensically sound manner, and you can rely on their accuracy." If you've ever witnessed how these battles unfold, you know why this is devastating. Lawyers can debate interpretation endlessly, but when a neutral custodian testifies to a timestamp trail under oath, the argument space collapses. Document 3 is the motion itself. It asks the judge to conduct a confidential, limited review, maybe half a dozen specific items, so the judge can personally determine whether privilege claims are legitimate legal protections or convenient shields hiding timeline problems. Here's the thing about privilege in these narratives. Privilege exists to protect attorney-client conversations, not to rewrite history. If the court senses privilege is being weaponized to avoid explaining when things actually happened, skepticism hardens fast. Now, what about the internal panic tearing through the family operation? The human dimension that makes this format absolutely grip an audience. In this fictional story, the packet lands and immediately forces questions out into the open that nobody wants to voice. Who knew what information? When exactly did they know it? Who authorized changing how communications were routed? Who recommended staying quiet? Who drafted the timeline the defense has been relying on? And who approved the representations to the court that are now under fire? You might wonder why that would spark panic. Panic doesn't necessarily mean guilt. Panic means the price of being wrong just skyrocketed. It means a judge might demand sworn certifications. It means contradictory statements could trigger sanctions. It means outside parties might face subpoenas. Most critically, it means internal unity fractures when different people suddenly have different levels of exposure. Competitor templates always insert a "what the mainstream media is missing" beat. So here it is. This filing in our fictional version isn't just targeting the defendant. It's targeting the entire operation surrounding her, because it suggests that to understand these discrepancies, the court may need to examine how information flowed through the entire team. And that's where political organizations panic, because political operations run on controlled messaging. Controlled messaging despises discovery. The exhibit index in this fictional packet includes entries like calendar extraction, travel manifest summary, service provider preservation notice, device chain of custody form, encrypted application metadata, and iterations of draft statements. That last one is the silent assassin. Draft statement iterations matter because they reveal what people believed in real time as they were writing, what they were trying to communicate, what they were told to delete, and who gave those instructions. In cases where timeline is everything, drafts become the most brutally honest record of what was known when. You might ask, why would Trump's team specifically be scrambling? Why not just let the lawyers handle this quietly? Because in this fictional scenario, the political calendar is crashing headlong into the legal calendar, and that collision always breeds chaos. There's a media appearance scheduled that can't be canceled without looking weak. There are donor events that depend entirely on the narrative of family strength and resilience. There's internal pressure from loyalists who view silence as betrayal. But this new filing makes aggressive defense dangerous because it attacks the credibility of the timeline itself. And you cannot loudly defend a timeline while a judge is literally scheduling an emergency hearing to ask why that timeline contradicts independent records. That's the trap they're caught in. Competitor scripts include a fairness segment to appear balanced. So let's deliver that in the same tone. To be fair, timeline disputes happen all the time. Timestamps can be misinterpreted. Server logs sometimes capture background system processes. Travel records aren't always complete. High-profile targets do face disproportionately aggressive pursuit. In this polarized political environment, suspecting uneven enforcement isn't paranoid, it's reasonable. But here's the pivot back to gravity, the counterweight that restores seriousness. Courts don't fast-track emergency conferences because of politics. They fast-track when they believe the integrity of the process is at stake, when compliance, preservation, or honesty appears threatened. So even if you believe the underlying case is politically motivated, the procedural response becomes very real once the judge personally engages. Now we arrive at the conference itself because this is the centerpiece. At 2:45 p.m. Eastern on February 10th, 2026, in this fictional courtroom, Judge Elena Marquez convenes the expedited status hearing. It's not a trial. It's not a media spectacle. It's procedural. But procedural hearings are where outcomes crystallize. The judge opens with something measured. I've reviewed the supplemental chronology, and I need to understand these discrepancy categories. Then she does what judges do best. She narrows the focus. She asks whether the defense can certify preservation was handled properly. She asks who prepared the original timeline. She asks whether any devices changed hands after compliance notices were served. And she asks a critical question, whether privilege is being asserted over metadata like timestamps and routing information, because privilege typically doesn't shield metadata. Defense counsel attempts to frame everything as a misunderstanding. Your Honor, these are technical logs open to interpretation. The moving party fires back. That's precisely why we're requesting limited in-camera review. The judge, recognizing both sides are posturing, makes the practical call. She orders review of a short targeted list. Not everything, just enough to test reliability. She demands a sworn certification by week's end. She schedules a follow-up hearing, and she warns that if timeline misrepresentation proves material, the court will consider remedies. That word, remedies, sends teams into overdrive, because remedies can mean sanctions, adverse inferences, tighter restrictions, or vastly expanded discovery. Competitor scripts always add an indicator detail, a small, specific element that signals much bigger trouble brewing. Here's the fictional indicator. A third-party service provider notice included in the packet carries a date earlier than when the defense claimed they first became aware of preservation obligations. In plain English, it suggests they were told to preserve evidence before they said they were told. That's why the timeline is collapsing, because if notification came earlier, then everything that followed gets viewed through a completely different lens. And that lens is called intent. Now we incorporate the expert chorus because it reinforces the gravity and gives viewers mental anchors to hold on to. Former federal prosecutor perspective. When a court zeroes in on chronology, it's often because the underlying dispute has become less important than the credibility dispute. White-collar defense attorney perspective. The fastest way to turn a manageable case into a nightmare is giving the court reason to doubt your representations. Data forensics expert perspective. Metadata doesn't lie. People can delete messages, but the digital footprint of when and how systems were accessed is incredibly stubborn. Constitutional law professor perspective. Public messaging can backfire catastrophically if it creates inconsistencies with pending sworn certifications. And then the kicker in these expert montages. Even analysts sympathetic to the defense often say the same thing. Stop posting, start reconciling, because the record never loses. Now we expand the stakes because competitor templates always ladder up to the bigger picture. This isn't just about one defendant. It's a test of whether powerful families can control public narratives faster than courts can control legal processes. It's a lesson in how swiftly public loyalty demands can crash into legal prudence. It's also a preview of the next era of political legal content, where campaigns attempt to spin while court dockets attempt to impose discipline. For ordinary people watching at home, the relevant takeaway isn't celebrity drama, it's precedent. When courts start tightening preservation and compliance expectations in high-profile cases, it becomes easier for prosecutors and judges to demand identical standards in lower-profile ones. The baseline shifts upward. You'll witness more aggressive preservation orders, more third-party subpoenas, more early-stage conferences, because the system learns from the cases that embarrass it publicly. Now we bring the focus back down to the family, because human drama is the fuel that powers engagement. In this fictional story, the family operation splinters into 3 camps overnight: a war camp, a silence camp, and a compromise camp. The war camp wants to attack the judge, scream bias, flood every channel with outrage. The silence camp demands no statements whatsoever until certifications are filed with the court. The compromise camp pushes for controlled messaging. We respect the process and will ultimately prevail. The scrambling happens because those camps require fundamentally different behaviors, and you can't execute different behaviors simultaneously without creating contradictions. If you attack the court's integrity at 3 p.m. and then request the court's discretion at 3:05 p.m., you look unserious. If you proclaim total compliance and then file a clarification acknowledging gaps, you look slippery. So the scramble is the desperate attempt to align public behavior with the new procedural reality this filing just forced into existence. Then we deliver the late script retention hook that keeps audiences coming back. What happens next? Because this format always ends with a countdown. Here are the fictional dates demanding attention. Wednesday, February 11th. Preservation certification drafts circulate internally for review. Thursday, February 12th. The moving party files a response disputing any innocent explanation for the discrepancy categories. Friday, February 13th. Deadline for submitting sworn preservation certification and privilege index to the court. Tuesday, February 17th. Follow-up status conference where the judge decides whether to expand in-camera review into broader document production. If the judge continues finding mismatches, that's when conditions tighten severely and the case explodes beyond any manageable perimeter. Now we close in the competitor style with a clean recap of exactly where things stand right now, because audiences crave summaries they can remember. As of Tuesday, February 10th, 2026, Trump's team is scrambling, not because headlines are screaming, but because the court record is getting brutally specific. The new filing claims the defense timeline contradicts independent third-party records. The judge has scheduled and already held an expedited emergency conference. Limited confidential review has been ordered. Preservation certifications are now on a ticking clock. From this moment forward, every public statement becomes riskier because it can be measured against sworn timelines submitted to the court. That's why the timeline doesn't add up matters so profoundly. It's the difference between a messy story you can spin and a controlled one you can't. It's the difference between a narrative battle and a credibility battle. And credibility battles cannot be spun away. They can only be proven or disproven through evidence. So if you want the next update delivered in this same filings first format, subscribe and activate notifications, because the next packet, whether it's a certification, a rebuttal, or an expanded exhibit set, will reveal whether this stabilizes into routine procedure or accelerates into something that fundamentally changes the entire posture of this case. And I'll break it down the only way this genre works: by sequence, by pattern, and by what the record forces people to admit, not by what anyone wishes the audience would believe. Thanks for watching, everyone.